I was only gone 30 minutes, a quick run to pick up a part from the hardware store, and when I pulled back into my own driveway, I found a locksmith's van parked beside my detached workshop, my side door standing wide open, and a woman I recognized instantly standing in my own driveway, directing two men carrying a toolbox and a battery-powered angle grinder toward my garage like she owned the place herself. My name is Emery Hadfield. I'm 46 years old, and my wife Dana and I have lived in a house inside a community called Brookhollow Terrace for almost 9 years, on a property with a detached workshop out back where I've run a small custom woodworking business on the side for most of that time, building furniture and cabinetry for local clients while keeping my regular job during the week. That workshop, a converted outbuilding that predated our purchase of the property by over a decade according to the original permits I'd pulled myself years earlier when I first moved in, had become the subject of an increasingly bitter dispute with our HOA president over the preceding several months. A dispute that, until that 30-minute trip to the hardware store, I genuinely believed was still working its way through a normal, if frustrating, appeals process. The HOA president, a woman named Vivienne Croft, had taken issue with my workshop almost from the moment she was elected roughly a year and a half earlier, arguing that the structure violated a provision in the community's updated architectural guidelines restricting detached buildings used for any commercial purpose, a provision that had been added to the bylaws well after I'd originally built out the workshop for my woodworking business, and one I'd contested from the very beginning on the grounds that my use predated the rule change and should reasonably have been grandfathered in, the same way several other long-standing structures throughout Brookhollow Terrace clearly had been. I'd hired an attorney early on, a sharp and patient woman named Camille Nakamura, who specialized in HOA compliance disputes, and together we'd been working through a formal appeal with the community's Architectural Review Board for nearly 4 months, a process that, frustrating as it was, still felt like it was proceeding through legitimate channels right up until the morning everything changed. We had a hearing scheduled in front of that review board in less than 3 weeks, and Camille had told me, based on the grandfathering precedent she'd already identified in 2 similar disputes elsewhere in the community, that she felt genuinely optimistic about our chances of resolving the whole thing in my favor without ever needing to escalate beyond the HOA's own internal process. I want to be clear that nothing about that ongoing appeal gave Vivienne Croft or anyone connected to the HOA board any legal authority whatsoever to enter my private property without my consent, a fact I understood clearly enough from my very first conversation with Camille months earlier, and a fact that made what I found in my driveway that afternoon considerably more serious than a simple continuation of an already tense dispute. I'd left the house around 2 in the afternoon for what should have been a routine 20-minute round trip to grab a replacement hinge for a cabinet door I was finishing for a client, a trip that stretched closer to 30 minutes only because the hardware store was busier than usual that particular Tuesday. Dana was at work, the house was empty, and as far as I knew when I pulled out of the driveway, my workshop was locked exactly the way I left it every single time I wasn't physically present, a habit I'd kept up for years regardless of any ongoing HOA dispute simply because it held tools and client projects worth a genuinely significant amount of money. When I pulled back in, the first thing I noticed was the locksmith's van, parked at an angle across part of my own driveway as though whoever parked it hadn't given a second thought to whose property it actually was. The second thing I noticed was my workshop's side door standing fully open, a door I was completely certain I'd locked less than 30 minutes earlier, the same certainty I'd have about locking my own front door before leaving for a vacation. The third thing I noticed, standing in the middle of my own driveway directing 2 men toward that open door, was Vivienne Croft herself, dressed like she was overseeing a routine inspection rather than what was actually happening, which was an unauthorized entry into a locked private structure on land she had absolutely no legal right to access without my consent. I parked my truck at an angle that, I'll admit, was at least partly intended to block the locksmith's van from leaving easily, walked straight up to Vivienne and asked her, as calmly as I could manage given the circumstances, exactly what she thought she was doing standing in my driveway, directing strangers into my locked workshop. Her answer, delivered with a confidence that genuinely startled me given everything happening around her, was that the HOA's legal counsel had advised the board that ongoing non-compliance with the architectural guidelines gave the community reasonable authority to conduct a compliance inspection, and that since I hadn't been home to grant access voluntarily, she'd made the decision to have a locksmith open the structure so the inspection could proceed on schedule. I want to say plainly that nothing about that explanation made any legal sense whatsoever, a fact Camille confirmed for me in blunt terms less than 10 minutes later when I called her directly from my own driveway, phone in one hand, while I kept the other eye firmly on the two men who'd stopped moving toward my workshop door the moment they realized I'd actually come back. An HOA's authority to enforce architectural guidelines, Camille told me, flatly and without hesitation, extends to fines, liens, and formal legal action pursued through the courts. It does not, under any circumstances, extend to authorizing a locksmith to break into a private structure without the owner's consent, a warrant, or any other legitimate legal authorization, regardless of what any board member's personal understanding of their own authority happened to be. I called the sheriff's department next, and while I waited for a deputy to arrive, I did the one thing that ended up mattering more than almost anything else that followed, which was pull up the footage from a small battery-powered security camera I'd installed above my workshop's side door about a year earlier, mostly as protection against tool theft rather than anything to do with the HOA dispute, footage that had been quietly recording the entire time I was gone. Capturing Vivienne Croft directing the locksmith crew to the door, capturing the locksmith actually picking the lock rather than using any legitimate key, and capturing all three of them stepping fully inside my workshop and beginning to move around near my tools and several client projects sitting mid-completion on my workbench. Footage time-stamped clearly enough to leave absolutely no ambiguity about what had happened or how long it had been going on before I got back. A deputy named Colby arrived within about 15 minutes, and I want to describe the shift in Vivienne Croft's demeanor once he actually started asking questions, because it was noticeable even to me standing off to the side. She'd walked into that conversation with the same confident, almost bureaucratic certainty she'd shown me directly, explaining her understanding of the HOA's compliance authority as though she were reciting settled law. The confidence didn't survive more than a few minutes of Deputy Colby's questions, particularly once he asked, directly and repeatedly, whether she had obtained my consent, a warrant, or any other legal authorization before having a locksmith open a locked private structure, a question she ultimately couldn't answer with anything beyond her own belief that the ongoing architectural dispute somehow provided that authority on its own. Deputy Colby reviewed my camera footage on the spot, confirmed with the locksmith directly that he'd been hired that same morning by Vivienne Croft specifically to open a locked structure without any property owner present or any documentation beyond a brief written authorization from the HOA board itself, and informed Vivienne, in terms that left no real room for interpretation, that what had happened constituted breaking and entering onto private property. A serious criminal matter, regardless of whatever internal HOA compliance dispute had been ongoing beforehand. I stood in my own driveway watching Deputy Colby explain, patiently but firmly, that an HOA board's authority to enforce its own architectural guidelines through fines, liens, or civil court action has absolutely nothing to do with a right to physically break into a resident's locked structure, and I remember thinking, even in that moment, that this had just become an entirely different situation than the frustrating but fundamentally civil appeals process Camille and I had been working through for the preceding 4 months. Deputy Colby didn't make an arrest on the spot, but he made it clear before he left that the incident was being formally documented as a breaking and entering complaint, and that the case would be forwarded to the county prosecutor's office for review, given the strength of the camera footage and the locksmith's own straightforward confirmation of what had actually happened that afternoon. He also strongly recommended, in a conversation I've thought back on more than a few times since, that I preserve every piece of footage and documentation I had, because in his experience, cases involving this kind of unauthorized entry tended to move a lot faster once prosecutors saw exactly how clear the evidence was. He was right about that. Camille filed a formal complaint with the county prosecutor's office the very next morning, attaching my camera footage, Deputy Colby's incident report, and a detailed timeline establishing that Vivienne Croft had arranged the locksmith's visit that same morning, coordinated the timing specifically around when she apparently believed my house would be empty based on my typical Tuesday schedule, a detail that, once it came out during the investigation, made the entire incident look considerably less like a good faith misunderstanding about HOA authority and considerably more like a deliberate decision to enter my property specifically because she expected no one would be there to stop her. The prosecutor's office moved on the case within about 3 weeks, filing formal breaking and entering charges against Vivienne Croft personally and a related charge against the locksmith, a man named Milo Strickland, whose own attorney argued, somewhat successfully as it turned out, that he genuinely believed the HOA board possessed legitimate authority to authorize the entry. An argument that carried enough weight with the prosecutor's office that his charges were eventually reduced considerably in exchange for his full cooperation and detailed testimony about exactly what Vivienne had told him when she hired him for the job. Vivienne's own defense, once the case moved forward, tried to lean heavily on the argument that the HOA's governing documents granted the board broad authority to ensure architectural compliance, an argument her own criminal defense attorney apparently tried to frame as a reasonable, good-faith misunderstanding of the board's legal authority rather than a deliberate criminal act. Camille, working the parallel civil case on my behalf by that point, made sure the court had access to the HOA's actual governing documents directly, which once anyone actually read them carefully, contained no language whatsoever suggesting the board had authority to physically enter locked private structures without consent, only standard provisions covering fines, liens, and referral to civil court for unresolved architectural violations. Exactly the kind of legitimate enforcement mechanism Vivienne had simply chosen to bypass entirely in favor of a locksmith and an empty driveway. The criminal case against Vivienne Croft went in front of a judge named Everett Sandoval roughly 5 months after the incident, and the camera footage, played in full during the hearing, left very little room for the kind of good-faith interpretation her defense had been trying to build. Judge Sandoval, according to Camille's account of the proceedings, seemed particularly struck by the timing detail, the fact that Vivienne had specifically arranged the visit around a window. She expected the house to be empty, a choice that undercut any argument that she'd simply been conducting an open, above-board compliance inspection rather than something considerably closer to a deliberate, calculated act of unauthorized entry. Judge Sandoval convicted Vivienne Croft on the breaking and entering charge, imposing a sentence that included a suspended jail term contingent on strict future compliance, a substantial fine, and a formal restitution order connected to the emotional distress and security concerns Dana and I had documented in victim impact statements we'd both submitted ahead of sentencing, statements that described, honestly, just how unsettling it had been to realize that someone with a personal grudge against my business had felt entitled enough to break into a locked structure on my own property while I was 30 minutes away buying a cabinet hinge. The civil case Camille pursued alongside the criminal proceedings resulted in a separate judgment covering the actual costs connected to the break-in itself, replacing the damaged lock. A security system upgrade I felt genuinely necessary after everything that happened, and a portion of ongoing legal fees connected to defending against what I considered, and what the court ultimately agreed was, an entirely improper attempt to circumvent the legitimate architectural appeals process Camille and I had already been working through in good faith for months before any of this happened. The original architectural dispute over my workshop itself, the thing that had started this entire chain of events in the first place, actually resolved in my favor about 6 weeks after the break-in. Once the review board, operating under new leadership after Vivienne's arrest, triggered an emergency board reshuffling, reviewed Camille's grandfathering argument on its own merits without the personal animosity that had apparently been driving Vivienne's approach to the dispute from the very beginning, and formally confirmed that my workshop's pre-existing commercial use was protected under the community's own grandfathering provisions, exactly the outcome Camille had told me she expected months earlier, before any of this ever needed to involve a locksmith, a deputy, or a criminal courtroom. Vivienne Croft was formally removed from the HOA board within days of her conviction, a removal the remaining board members apparently didn't even debate especially long given the exposure her personal conduct had created for the entire community, exposure that, according to a couple of neighbors who kept me informed over the following months, ultimately cost Brookhollow Terrace a noticeable increase in its liability insurance premiums once the carrier reviewed the details of what one board member's individual decision-making had actually resulted in. My workshop has sat exactly where it's always been for the 7 months since, locked the same way it always was, running my woodworking business the same way it has for most of the past decade, though I'll admit I check that side door camera footage a little more often than I probably need to these days, a habit I don't imagine I'll break anytime soon given everything that happened the one time I let myself believe 30 minutes away from home was too short a window for anything to actually go wrong. I think about that afternoon sometimes, standing in that same driveway now, watching Dana pull in from work the way she has every evening for years, without incident. Vivienne Croft spent a year and a half convinced that a title and a set of architectural guidelines gave her the authority to do whatever she personally believed necessary to bring my property into line with her own preferences, right up until the exact moment a locksmith's pick, a battery-powered camera, and 30 minutes at the hardware store proved, in the clearest possible terms, exactly how wrong she actually was. Thumbnail text: she broke in while I was gone, and my camera caught it all.